When you need to build up your team to handle the growing chaos at work, use Indeed Sponsored Jobs. It gives your job post the boost it needs to be seen and helps reach people with the right skills, certifications, and more. Spend less time searching and more time actually interviewing candidates who check all your boxes. Listeners of this show will get a $75 sponsored job credit at Indeed.com/podcast. That's Indeed.com/podcast. Terms and conditions apply. Need a hiring hero? This is a job for Indeed Sponsored Jobs.
Welcome to the Monopoly Report. The Monopoly Report is dedicated to analyzing the big issues impacting the global advertising economy. I'm Alan Chapell, outside counsel and fractional chief privacy officer to a bunch of tech companies, and am the principal analyst at the Chapell Regulatory Insider, which is a monthly report that focuses on privacy, antitrust, and other regulations impacting digital media worldwide. You can find a link to the sample copy of the Chapell Regulatory Insider in the show notes. Let me start with a question that might sound simple, but really isn't. Who decides what you are allowed to keep private? Not in theory, but in practice. When you send a text, search for a doctor, or let your phone tell you the fastest way home, somebody somewhere is making a decision about who else gets to see that communication. And for the last 30 years, the people fighting to make sure that decision lands in your favor includes my guest today, Cindy Cohn. Cindy is an American civil liberties attorney specializing in internet law. She served as an executive director for the Electronic Frontier Foundation from 2015 to 2026. Cindy has just released a wonderful book that I highly recommend. It is both a professional memoir and a manifesto titled Privacy's Defender, My 30-Year Fight Against Digital Surveillance. Cindy's book details her decades-long career defending digital privacy, human rights, and free expression online. I'll place a link to Cindy's book in the show notes and encourage you all to buy it. Cindy was at the EFF for over 26 years. Before that, she was what she charmingly calls a baby lawyer at a small firm, taking on a pro bono case that most people thought was unwinnable. That was the Bernstein case. The U.S. government had classified encryption software as a weapon. Cindy argued that code is speech, that it deserved First Amendment protections, and that all of us were going to need the ability to keep secrets as we moved into the digital age. Cindy and her team won. And if you've ever bought anything online, banked from your couch, or sent a message you'd rather not broadcast to the world, you have benefited from that win. So we're going to talk about Cindy's illustrious career, but we'll also touch on other topics such as how timid courts have become in a post-9/11 world, why a single all-powerful privacy regulator might be a terrible idea, and the private right of action as an enforcement mechanism, behavioral advertising, surveillance pricing, and whether publishers could actually keep the lights on with contextual ads alone. And because this is the Monopoly Report, we'll spend a bit of time talking about the connection between privacy law and competition law. As I noted above, Cindy's new book is called Privacy's Defender. It's a great read if you love privacy and want to know a bit more about the history of privacy in the U.S. It's also helpful if you want to understand a bit more about how we went from John Perry Barlow's libertarian mantra of keep government off my internet to the more toxic form of libertarianism we have today. So let's get to it. Here's Cindy Cohn. Hi, Cindy. Thanks for coming on the pod. How are you?
Oh, I'm well. Thank you so much for having me.
Where's my audience finding you today?
I'm in San Francisco. I live in the Mission District. I'm quite literally in my closet because it's the quietest place and where I record podcasts from. So,
oh, fantastic. Yeah, it's kind of nice to get that little confined space to record. I've been known to record vocal tracks, and if you kind of sing into the closet, that way in New York City, your neighbors don't scream at you because it sort of muffles it at least a little bit.
Well, this is a creaky old Victorian, beautiful old house, but finding a place that is not loud is very difficult. So,
understood. Yeah, same with New York City. So with your permission, I'd like to start with some of the cases described in the book and maybe dig into your mindset at the time. So you took on the Bernstein case out of a small firm. It was pro bono as what you had characterized as a baby lawyer. I love that term. What did you understand about the stakes of freeing encryption that perhaps others at the time did not?
Well, I mean, I wouldn't say I was entirely prescient, but it seemed very clear that, government saying software with the capability of maintaining secrecy is a weapon was wrong, and that we were all going to need software with the capability of maintaining secrecy as we were moving into the digital age. I think, I was an international human rights lawyer, that's kind of the frame I brought. So I was thinking a lot about the needs of people who want to organize for social change or political change to be able to do that in a private way without the government that they're opposing listening in. And so that was the frame in which I thought this was going to be really important. It turns out that encryption is really important for security as well. And, kind of protecting us against not just, government, but actual, kind of criminals and bad guys and things like that. And I don't think that was front of mind for me because I was really focused on the privacy side of encryption and not the security side at the time. But, I would argue that looking back, I don't know, they're not really in conflict, but the security side ended up being pretty darn important too.
Oh, absolutely. I think you can argue that there may not have been an Amazon, but for your work here.
I think that that's right. I think Commerce Online, certainly the voices that were pushing hard to try to get these encryption regulations lifted were folks that were interested in Commerce Online, but also just business online, secrets, business secrets and things like that. So the business interests were aligned with kind of, me and the crazy hackers and human rights people who wanted to do that. And I think it made us have a particularly big voice in the fight.
I think this was covered in the book, but I'm curious, did you study human rights law?
Yeah, in law school, I did. And then I did a fellowship at the UN Center for Human Rights in Geneva right out of law school. That was what I was interested in doing. And I had studied it, in undergrad as well. I got to sit in on a law school course when I was in undergrad about human rights because I was early on kind of fascinated. And I remember this was the time, I'm an old lady. This was the time when we were talking about apartheid in South Africa. Later, we were talking about Central America and a lot of the issues around there.
Well, I remember, so one of the reasons I got into privacy is I went into law school and I wasn't really sure what I wanted to do with it. And I thought two things jumped out at me: human rights law and European Union law. And it turns out that, and look, I wasn't prescient at all here. I was just sort of doing what I thought might be interesting. But it turned out that if one wanted to go into the privacy world, human rights was certainly not a bad way to go.
No, I think it is. I think it's a good framing. I still love the international human rights framing of surveillance, for instance, as looking at whether it's necessary and proportionate, which is how it addresses it. It's such a really powerful way to begin to look at all kinds of surveillance. But I really like the framing in the international law stuff. It's a lot easier than trying to kind of deal with the 1700s thinking about, the Fourth Amendment and being secure in your papers and things like that. I think necessary and proportionate ends up being concepts that are a little more robust to technological change.
So I was recently watching a documentary on Steve Martin, and a huge fan. He's such a talent and hugely accomplished as an actor and a writer. But there was a period of time in the 1970s, and I can kind of remember this from TV. I mean, he was an absolute flat out megastar, stadium tours, huge media saturation. And I was struck in the documentary by the way that success had sort of influenced how he perceived the rest of his career. And so bringing this around to you almost started off your career with this huge win, the Bernstein case. And how did that big win impact your thinking and approach going forward?
Yeah, I think you're exactly right. And I mean, I'm nowhere near like Steve Martin, but I think, I've often joked that it's a little like when you first rock into the casino, right? And you win the very first time. It keeps you coming back. I think that is part of the reason why I continue to really enjoy and feel energized by the litigation process, in part because we were kind of nobodies and we showed up and we were right and we won. And so I kind of think of the courts as a place where it's not guaranteed, but it's possible that if you don't have any connections, you don't know anybody, you're not important, you can still present your case. The judge can look at it and you can win. So I felt like, certainly compared to the other two branches of government, the judiciary offered the opportunity for that. And I think that one of the things that then has been frustrating since 9/11 was the increasing timidity of the courts to really apply the same amount of analysis to national security claims by the government as they do to any other kinds of claims by the government. And, in the Bernstein case, we were up against national security claims, but we had a judge and judges who were not willing to suspend their judicial analysis because the government came in and waved a national security flag. And that really changed after 9/11. And I think having done the Bernstein case, I was first of all, I was really angry about it and frustrated about it, but also willing to continue to push because I know there's a better version of the judiciary out there. I experienced it. And I feel like if we just keep pushing, we can begin to, shift the judiciary back into a place where they're just willing to give the same analysis in a national security case in terms of evaluating the government's arguments as they do in other cases. That's a very legal geekery answer. Sorry, that's a very
no. It is. I don't see that at all. And you actually went in the exact direction I was hoping you'd go. It isn't just national security. There's a component here that just philosophically, the courts are very different than they were in the early to mid 80s. And I'm just curious if you have the same level of optimism regarding the courts. I mean, are they at this point just the least bad option?
Yeah, I mean, it's hard to. I do think that it's much worse. Certainly at the Supreme Court level, it's very problematic, and in some ways, I wouldn't even call them the least bad option at this point. They're kind of driving things in a very bad direction in terms of empowering the executive. I mean, again, there's lots of specific things that I don't like in the specific decision making of the court, but the overall thing is that I think underlies a lot of this is they're really letting the executive branch become the most. Become the one branch that rules them all, right? They're supporting an imperial presidency that I think is very dangerous in all sorts of things that I care about substantively. So I really worry. Now, I don't want to throw the whole branch under the bus because there are plenty of very courageous judges right now, especially when we're looking at some of the ICE cases and some of the Trump administration cases. We are seeing courts having to be not just courageous in the face of national security claims, but courageous in the face of very direct attacks, personal attacks against them. And I really want to make sure that we're not counting them all with one broad brush because that's not the case. But overall, I do think that there's been a shift and that it's very dangerous. And we have to find a way to really address that shift if we're going to get back to a place where the courts can be a place where people without power can win. And I don't want to say that the 80s were a perfect time. I think there's plenty of really good analysis that show that overall, and in many, many cases, the courts are really a reinforcer of power, not a standing up to power. But, I kind of grew up and cut my teeth on some of the counter examples, and I'd like to see them strengthen.
And maybe that's just the trick, is finding the zones where one can be optimistic. I want to return to the book a little bit because I want to. So you won Bernstein, and the government had backed down, and thank you, because we're all enjoying the fruits of that. But then the Snowden affair had demonstrated that the NSA had really gone through the back door, hollowing out at least part of the victory. So walk us through what happened when the EFF sued AT&T and then eventually the government, and what led to Snowden demonstrating that the government was in fact lying.
Yeah. So, we started hearing rumors after September 11th that there was some kind of massive spying thing happening. And people would kind of say, we can't tell you about it, but it's huge. Or, EFF would be very upset if they knew. But we were trying to pull together enough evidence to actually have a lawsuit that could survive kind of the initial step where you have to have some evidence when you show up in court. And we knew that this was a national security case, so we needed to have probably more evidence than you would need to have in a regular case. I'm not sure that's great, but it's certainly the situation. So we were digging around. We were thinking about legal theories. And then in late 2005, the New York Times ran a story about the Bush administration spying domestically in the United States. And about 3 weeks after that, we were in our offices on Shotwell Street here in the Mission in San Francisco. And literally a guy in a trench coat knocked on our front door. And he said, do you people care about privacy? He had kind of a raspy voice, and I can't do the Long Island accent. And my boss, Sherry Steele, let him in and said, yes, we do. And he showed up. His name was Mark Klein. He had a bunch of paper and pictures of the mass spying apparatus that had been installed at the AT&T facility in downtown San Francisco, and a room called Room 641A, where a copy of everybody's communications that travel over the fiber optic cables that carry our communications. And this is right at the juncture, one of the junctures where communications that are domestic leave the AT&T domestic thing and go out to the broader internet, including internationally. These are called peering links. And they had installed an ability to make a copy of all the traffic going through these peering links, and one copy went off to the internet and the other copy went into a room that you couldn't get into unless you had NSA clearance. Mark had helped hook up this set of connections at the peering links, and he kind of thought something was weird about it. Then he retired from AT&T. He kept copies of this stuff, and he showed up at our front door with it. And this was the evidence we needed to launch litigation about these stories that we had been hearing. And we actually sued over that program, which ultimately we learned was called the Upstream program, and two other programs that we had evidence about: the massive telephone records collection and the massive internet metadata collection. So we sued all three of these things. We sued AT&T first because AT&T as a telephone company had a legal duty to do nothing with your communications other than deliver them to where they go and protect their own networks. And handing everything over to a room controlled by the NSA isn't either one of those things. So we sued the company directly because the government has a lot of immunities and hoops you have to go through before you could sue them. And we thought the case against AT&T was cleaner. This was the brainchild of my colleague at the time, Kevin Bankston. So we brought the lawsuit. It was called Hepting versus AT&T. And we were chugging along and doing okay. We won in the first motion, and we went up to the Ninth Circuit, and the argument went quite well. Then we learned that AT&T and the government were going to Congress to try to get AT&T out of this lawsuit. There were many lawsuits at this point in time. Once we sued, there was a whole bunch more. And they went to the Congress, and they got retroactive immunity for this violation of our rights. That's not a thing that existed before, but they got it passed, and that killed our first case against the phone companies. They got retroactive immunity for what they'd done to violate our privacy for many years. So we launched a second case against the government, against the NSA. That case is called Jewel versus NSA. So this is, going on for quite a while. We're still struggling. The government is still neither confirming nor denying that they're doing it, and basically insinuating that we're making it all up. So this is 2006, 2007, 2008. Then in 2013, Mr. Snowden shows up on the scene and presents so much information about the mass spying that we'd been suing over for all these years that the government, the Obama administration, could no longer really confirm or deny it. And they actually confirmed that it was happening. So Mr. Snowden did a huge favor to, me and my lawsuit, but American people by forcing the government to stop playing games about the mass spying it was doing that implicated many millions of people's communications that went into this secret room, and making it so the government could no longer deny it. And the first question I got from him through his lawyer, Ben Weisner at the ACLU, was, so do you guys have standing now? Indicating that the government's refusal to affirm or deny had meant that we were really kind of stuck in the starting blocks in our cases. And he was trying to make sure that they couldn't deny it anymore. That's how kind of Mr. Snowden came in much later and presented so much evidence about the spying that the government could no longer play the games it had been playing about it. which is one of the reasons why when people are like, well, Snowden could have just done a little, he didn't have to do a lot, and maybe he didn't need to release as much information as he released. While I understand that from people who aren't deep in the fight, it misunderstands some of the problem that he was trying to address, which is the government playing a lot of games with the little bits of information we got and presenting so much information that they really had to change their posture.
But also, this isn't a situation where you want to just release a little bit, because if you didn't release enough, boy, it would be a shame to risk everything that Mr. Snowden has risked to not be successful. I mean, heck, I would err on the side of caution and make sure you guys had as much information as you needed.
Well, and we weren't the only reason he was mad. The immediate reason he was mad was because he caught a member of the National Security Administration. He saw him lying to Senator Wyden on national TV, right? When Wyden asked, is the NSA spying on millions of Americans? And he said, no, not wittingly. That was the immediate thing. But yeah, I think it really did require, look, if we had a government that just came clean with us and said, look, we think we need to spy on everybody in order to keep us safe, and we could have had a big public conversation about that, you wouldn't need whistleblowers. But in a self-governing society, it's not okay for the government to do massive spying and then lie to the American people about it.
Completely agree. And so I'm struck that, back then it was really the telcos who were sort of the choke point, the place where all of this data gets aggregated. And increasingly over the last, 15 or so years, it's been what we used to call the edge providers, who I guess we now refer to as big tech, are the ones that have this kind of information. So I've recently been using New York City's urban planner, Robert Moses, as a bit of an analogy, where infrastructure is in fact policy. The roads being built today are in some ways determining the internet of tomorrow. And so as you think back in your career and where you think your career might take you next, how do we fight against those centralized choke points? If the architecture is the problem, are courts and statutes necessarily even the right tools?
Well, I think we need all of the above approach to this. We didn't get into this situation because just architecture or just policy or just law. So we're not going to get out of it with just one of these things. And in fact, they're mutually reinforcing, right? I think one of the ways that we help build a more decentralized architecture is we attack the laws that are supporting it right now, including things that, have long been things that I care about, like the way computer crime laws, the Computer Fraud and Abuse Act, are used to try to stop people from creating interoperational tools that could help free us from the monopolies, right? That we've done a lot of work with developers who are trying to help free people from these monopolies who find themselves sued into a smoking hole because of the misuse of things like the Digital Millennium Copyright Act or the Computer Fraud and Abuse Act. So I think if you're going to look holistically at how we get out of this, you have to actually look at the laws that are getting in the way and a legal structure that would help facilitate a more decentralized world. And that gets you into things like monopoly, like competition law, as well as the kind of harder things like computer crime law that EFF has long challenged. So anybody who tells you that, that we just need to pick one tool and drop all the other tools is not understanding the scope of what we need to do to get to a better place. That's the bad news. It's not just a pick one kind of answer. But the good news is there's lots of ideas. It's not hard. New thinking is always welcome, but there's plenty of things that we could do because this hegemony came into existence because of some laws. It became, my friend Cory Doctorow does a bunch of work on this. His latest book, Shitification, really goes into this a lot about how the backing away from antitrust and competition laws and the redefining it as about consumer prices played a huge role in enabling the tech giants. The other thing I would point out is it's not like the telecommunications companies aren't still a vector of spying. They are a huge vector of spying. So we didn't replace one with the other. It's additive. Now we have two places to think about in terms of reining in the spying. Sadly, I wish that I could let the phone companies off the hook, but they still are unwilling to push back against the government in the way that even sometimes we see the tech companies doing a better job.
With the telcos, there's this sort of quirky little narrative that plays out every 2 to 4 years where there's a big promise to everybody, including the government, that we are not going to sell precise location data. And then you fast forward 2 years and it's really clockwork that it comes out that, oh no, in fact, we are doing that. And weirdly, sometimes they're not even hiding it. Like it's not hard to figure it out. And I'm always sort of amazed by that little sub narrative of all this.
Yeah, we sued them over it one of the times that they did. And then they said they were going to stop and they backed down. And, so we were unable to go forward with the case. And then, of course, they turned around and did it again. And, it may be 2 years, but I think it actually wafts with some of the political wins, right? If they've got people in charge of the FCC who are more friendly to them, then they do it again. And then when the FCC might turn into people who actually care about privacy, then they drop it, or at least, deprioritize it. That's kind of the way I see that pattern happening. And it's really important. I mean, one of the things, and this is kind of a legal wonkery, but one of the things that we see, there's effort sometimes in Congress to create a, what they call a comprehensive privacy law. And the last one that they tried to do didn't do a lot of the things that it needed to do, was very, very insufficient. But one of the sneaky things it did was it took the FCC's authority to regulate privacy away and made the FTC, the Federal Trade Commission, the only place that could regulate privacy. And that's exactly because the phone companies wanted to be able to sell this data, and their main regulator, their real regulator, is the FCC. So if they could take this power away from the FCC, it'd be open season for them.
They have that exactly backwards. Because I, by the way, I'm somewhat sympathetic to the telcos, because they're looking across the street at the edge providers and going, oh my goodness, it's a free for all over there. We want to get in on that. And leaving aside the moral angle to this, like, I can kind of understand a business looks across the street and they want to be able to make money too. But what should happen is you need all of those large companies regulated by the FCC or something similar to it. The problem in the US is that sounds an awful lot like the EU's DMA. And there's just like a reflexive, oh, no, we can never do that in the US. And boy, I really hope that narrative changes, because I think that would be a really, that would result in, I think, a much, much more sane regulatory environment, if nothing else.
I think that it could be, but I guess I have a note of caution for you about that. I think that I think I'd like one rule to rule them all, and not sure I want one agency to rule them all. And part of the concern about that is we've seen what happens when a despotic president comes in and takes charge of the agencies. You end
mean
up with
Obama, right?
Yeah, exactly. We're seeing with Brendan Carr what a powerful person in charge of a regulatory agency can do when they're deciding that their job is to, demonize the president's political enemies, or even people who make fun of him on TV. So I think we have to think not only about what regulation might look like. I'm not against regulation, but thinking about backstopping a regulatory power with checks and balances that are real. And that might point to a different direction than a comprehensive internet regulatory agency. To me, it points more to a comprehensive internet rule that ordinary people can enforce. Private rights of action, I'm a big fan of them. Other kinds of things. Again, there's plenty of regulation that you could do with a centralized regulatory agency, but you really have to think defensively about that, handing that kind of power to anybody.
Fair enough. And I was just more thinking the larger rule set. And by the way, one thing that you didn't mention is that they really have defanged the ability of regulatory agencies to really create policy. And so that's sort of a whole other set of issues.
Yeah, I mean, again, it kind of slides away from digital rights to the questions about, independent agencies and shoring up the idea that agencies are not just the agents of the president, but actually have an independent duty to the American people and the rule of law. That is not the same as you work for the president, you do what the president wants. And, that's one of the things that's happening in this particular moment is a lot of the tools that we use to try to make change are themselves under attack. And it's made us have to shift into like talking about three branches of government and independence of agencies and things like that at a level that, when I started out in the 90s, that stuff, that was taken for granted, and we were trying to make change within those power sources. And now in some ways we kind of have to protect the idea of separation of powers and those kinds of things in order to even get to the place where we can make the arguments that we need to make.
So you mentioned the private right of action a moment ago, and I come at this from a little bit more of a business community perspective, but I look at what's going on with the California Information Privacy Act or even VPPA, and some of that just seems insane to me because you're not really helping consumers. You're creating a whole bunch of challenges for the business community. And not to mention, there are a set of rules in California. The Cal Privacy folks are doing a great job of creating and enforcing their own rule set. So I guess I would love it if you had some thoughts on how one could do a private right of action that was a little bit more sane.
I mean, I actually think that right now, a lot of the hoops that people have to go through to be able to bring these kinds of challenges end up creating this whole side fight that isn't the important fight, right? And I think, again, I'm a litigator. I think that the courts are a good place to sort out some of these things if you give them the right tools to evaluate them. So, I think simpler rules are easier. I think that, I'm a huge fan of kind of basic ideas around privacy, like no secondary uses of data. If you give information to my phone company because I want my phone to ring, it can't turn around and sell that location data on the open market without something that's much, much higher than a click box, right? The rule is not hard. There might be some edge cases, but it's pretty easy. Or, I also like the fiduciary duty idea that we create duties in the people who handle our data to be loyal to us. Now, that could create a lot more gray spaces because what does loyalty look like and things like that. But we figured it out in negligence law, okay, and in some of the other things. Again, there might be a messy middle, but I'd rather see a messy middle than, the world now where people lose all control of their data when they give it to the first entity and it becomes theirs to control. So those are the kinds of things I'm thinking about. I mean, I would say that a world in which the companies get to decide what they're doing and they create a race to the bottom about all of our data and how the ways they can use it is a bad one. And we got to start playing around with different ideas for how to push back on that. And regulatory agencies are just not up to the size of the problem.
I had Tobias Juden on maybe 6 or 8 months ago from the Data Tilsynet, and he was talking about outlawing behavioral advertising in Norway. I actually like that idea just from a pure experimentation standpoint, because what I don't know is, will publishers be able to keep the lights on with contextual advertising? And I don't know the answer to that question, but I kind of feel like we should find out because the status quo just ain't working.
It really empowers the Googles and it empowers not the publishers, but the people that the publishers rely on and increasingly are under the thumb of, right? I mean, I think all the, talk to people about the pivot to video, right? Like, I just think that I agree. I think that outlawing and both of the things that I outlined as our strategies towards outlawing behavioral advertising, there's other ways as well. Again, I don't think the problem is that we haven't come up with the idea yet. I think the problem is we have to really try some things and to implement them. But yeah, I think that would be clear. Look, the internal studies that I've seen, and this was a couple years ago, so I may be a little out of date, is that the marginal benefit of behavioral advertising over contextual advertising is not very big. And the amount of control that behavioral advertising gives to the Googles and the Facebooks of the world over the publishers is huge. So I don't think, and most of that extra benefit doesn't go to the publishers, it goes to the intermediaries. And so I think if you want to redistribute power down to the actual publishers, one of the ways you can do that is outlawing behavioral advertising, because this is across the board, right? If a little more money stays in consumers' pockets because the amount of price discrimination that the companies can do as a result of losing behavioral advertising goes down again, like, I'm okay with that, right? Like, we've created these huge behemoth companies that are making a lot, like, okay, so, Sergey Brin doesn't get to buy off the California legislature nearly as often as he wants to because he's making a little less money. Like, I can live with that.
One thing I would point out, there's a recent study that actually, somewhat ironically, came out of the whole privacy sandbox debacle. Garrett Johnson, who I know is a frequent listener here, they did a pretty significant study comparing status quo with cookies, without cookies, and then with the privacy sandbox tools. And I'll put it in the show notes. I'd encourage you to take a look at it because it was fairly significant, the benefit to publishers. But you do raise a good question, which is like, what percentage of that additional revenue actually ends up in the hands of publishers? And that's been an endemic challenge for, well, only 2 decades. So hopefully in decade 3, we'll start to get that right.
Well, it is fairly new, right? And so that's the good news is like there was a time when that wasn't the case. And many of us were alive then. So it's not, I always say, Moses didn't come down off the mountain with stone tablets that said the only way to make money on the internet is by spying on everyone. So the good news is it's fairly recent. And I helped it free up encryption, that it did make commerce on the internet something we could do. But I also think that it's not either or, right? We can have a commerce system that's fair to everybody. And I honestly, the publishers, I care about them, but I also care about the users. And I really worry about the amount of price discrimination we're starting to see in the way that behavioral advertising is being used to maximize the amount of money that people can pay. And also taking advantage of people who are not able to pay more. There was a story I heard recently, and I do need to confirm this, but that there were some large employers who were figuring out how desperate people were for jobs in order to decide how much they were going to offer them in pay. Because if you're desperate, you'll work for a lot less. And I just think that most people find that to be dramatically unfair. It's capable of behavioral advertising can give you that information, and AI is making this stuff a lot easier to do at scale. I think that really fundamentally breaks some fairness for people, and it's all enabled by behavioral advertising.
I've read that in the context of, I think, some of the food delivery apps, something like that. And so maybe we're just both reviewing the same incorrect source, but I've seen that in a couple of places.
It's not a secret that that's what they'd like to do, right? This is an old economics idea, right? You want to maximize the amount. So it's true that I agree with you that I'm not sure that I've confirmed these examples, but it is not just like the idea that the NSA would like to surveil the whole world and they think that would make everybody safer. Like, they are very clear that that's what they would like to be able to do.
For sure.
Price discrimination is something that is very clear that people would like to be able to do. And I don't think we should rest easy that the technology doesn't make that possible, because I think it does.
I was really disappointed. There was an airline that sort of got caught red-handed doing that. And again, I come at things from the point of the view of the business community, and what that is going to spawn. Already in New York, and I think there's 2 other states, have specific price discrimination laws. Like surveillance pricing, I think is the pejorative term. And that is going to screw things up for the rest of the business community in all kinds of ways, because that stuff is sometimes a little tricky to define. It ends up being either overbroad or they haven't quite figured. It may take a while to figure that out. And the constituency that I tend to work with are the smaller to mid-size, VC-funded companies. And those are the same ones that have a problem with some of the private right of action, because they don't have the legal budgets to withstand an inquiry around this. And even if they aren't doing it, it still becomes a problematic issue because it creates a whole bunch of friction.
I hear you on that.
I know you're not crying.
I'm more on the consumer side. I mean, I want small businesses to succeed, but right now we're in this tremendous race to the bottom, and we have to find a way to stop the race to the bottom. And
okay.
I think that a lot of companies, little companies, the big companies are facilitating at a much greater level. So, hopefully there's a way that we can scale our response. Because I do worry about rules. And I think that the GDPR and some of the European approaches, create this regulatory world in which only the big ones can survive, right? And I think you have to pay attention. It's not to regulate or not to regulate. You have to think about ways to write laws that are smart, but also are enforceable. And we have a lot of rules right now that are not enforceable because no FTC or state attorneys general are picking up the mantle, but yet people are getting hurt.
I agree with that. I also agree, though, that there is a sort of an endemic challenge in that you're throwing out, I don't want to say it's the baby, because I'm not saying that the small to mid-sized guys are entirely innocent here. But in the search to stop the race for the bottom, it doesn't seem like that effort is really hitting big tech. It tends to really hit the small to mid-size. And so from my perspective, maybe we could try something else. And the something else, I think, needs to be competition law.
Yeah, well, I'm with you on that, and I worry about the same things you do. I mean, this makes EFF a little different than a lot of other privacy groups in that we have this recognition that simply regulate now is not actually a very good answer, and will, if not carefully thought through, entrench the powerful rather than freeing up the kind of competition that we need to get out of the world of the big five tech giants. And it puts us at cross purposes with a lot of our friends. I don't see private right of action as the primary vector of that. I actually see other things that I would put higher on my list, and you and I might disagree about them. But I agree with you. We are very sensitive to the kind of big regulation strategy, which feels really comfortable and is simple to say, but actually ends up with, when Sam Altman went to Congress and said, regulate us, everybody's like, oh my God, finally a billionaire who gets it. And then you saw what OpenAI put out as the regulation. It would make it so that there's nobody but OpenAI able to do what they do. And I'm much more interested in the kind of regulation that empowers competition rather than the kind that squelches it. And that takes a little harder thinking.
So one idea that has clearly stayed with you, because I've seen it in the book a bunch, rights are not handed over. They're taken and then defended every generation. So at some point, that concept feels exhausting. And I don't want to get into this those damn kids today. So let me ask it this way. You said that privacy is a team sport. What gives you the hope that the current or the next generation is going to be willing to pick up that fight?
Well, I think they are. I mean, I live at EFF. We have no shortage of young, amazing, innovative people who are excited and who want to step up and help make a better world. And they're there. I think there is this common idea that is trying to be sold to us that, privacy is dead, get over it. There's nothing you can do. Nihilism, nothing you can do matters. Or, if you have nothing to hide, you have nothing to fear. I would say that among the more junior people that I talk to, the nihilism one is stronger than the I have nothing to hide, I have nothing to fear. Because I think most of them.
Yeah, that's my parents' generation.
Yeah, most people understand that that only works if you're already at the top of society and doesn't work for people who are not at the top of society. So it's an entitled position. And I think that that's true. Or really old people who lived through World War II or have that generation, they get that everybody has something to hide and everybody has something to fear. So there's this interesting generational differences. But for the younger people, they want to be online. They want to use the tools. They want the tools to stand with them. There are tons of them. And I think in some ways I wrote the book because I feel like I wanted to speak to those people to say that if you lean in and, I hate using that term, sorry, but if you actually decide that you want to devote your life to doing this kind of work, it can be fun. It can be interesting. I've always made enough money to feed my dogs, which is the most important thing. And, you don't get rich, but you don't starve either. And that it can be fun, and that the people who you get to do this work with are amazing people. I joke that, the good guys throw better parties than the bad guys. And so that's where all of this team sport idea comes from. It's something that people can do. You should think about it as something you can devote your life to. I hope that my book, because I tell the personal story as well as the professional story, kind of can help inspire people to think that spending your life doing things better can be an interesting life. I read a couple of those books when I was a young lawyer by the generation in front of me. None of those people did digital rights, right? Like my job didn't even exist. But they inspired me to think, okay, I can spend a life devoted to trying to make things better and have interesting and fun things happen. So, that's kind of I say from the very beginning of the book, I'm trying to recruit you. I really hoped to tell a story that might help people who are newer thinking about their careers and how they want to spend their life to think that this is something that they could do too. And I think it's important because we get better at this the longer we do it. Like people who, like I have all the respect for the people who, go to their day job and in the night volunteer for things that they're doing or spend a year or two doing public interest work and then have to go get a real job. No shade on them at all. But if we want to have a chance of winning these fights, we need people who can devote 26 years of their life full time fighting these fights because we get better at it. We learn along the way. The Justice Department's lawyers stay there for just as long. And so we need to, and the corporate lawyers are going to be there for just as long. So we need to develop in civil society that same kind of ability to do this for the long run.
So Cindy, thank you so much for coming on. I encourage my audience to buy your book. I loved it because it melds two of the things that are most important to me in my life, the privacy angle, but also the music. So I wanted to close with what might be my toughest question. You've spent a lot of time in Mill Valley, and as have I over the years. And there's a venue called the Sweetwater. What is your favorite concert? What is the most interesting concert that you've seen at the Sweetwater over the years?
Oh my God, I've seen so many things at the Sweetwater. So the Sweetwater is, co-owned by Bob Weir of the Grateful Dead. And I would say that the most was when John Perry Barlow was ill and needed some money. Bob Weir put on a benefit concert for Barlow. I think there were 2 nights of it at the Sweetwater where a just incredible range of people showed up and did a song or two. And I don't think there was a dry eye at the house. At one time or another, we were all crying and laughing and dancing together, in honor and to support, my dear friend, John Perry Barlow. And I would say that that's the one when you mentioned it that came up immediately in my head. We just recently had another benefit concert for a friend of mine named Danny, whose husband is a lead guitar in a band I'm friends with named New Monsoon. We also did it at the Sweetwater and Danny. So I would say the ones that touch my heart are the ones where we really come together as a community to share music in honor of people who are going through rough times. And I've been lucky that the Sweetwater has been the home for a bunch of those.
Yeah, it's just such a gift that venue. By the way, for me, mine isn't quite as noble, but I saw Jeanette Napolitano, who was the lead singer for Concrete Blonde, play an acoustic show. I'm going to say this was 8 to 10 years ago, but oh my goodness, what a monster talent.
Yeah, I had a similar experience with Allison Russell. I don't know if you know her, but she and her band, those pin drop moments, right, in a show where you just are in awe of somebody's talent. I definitely had some of that with Allison. I understand your feeling about it. It's a great venue. We're blessed here in the Bay Area. I feel blessed to have such a strong music community, and it really is. I put it intentionally into the book because I really wanted it to talk about how you do this for the long run, how you sustain it, how do you find the kind of balance to not burn out. And it's certainly the music community in the Bay Area is central to how I have been able to do it in the long run. Plenty of people, that's not their thing, right? And especially it might be at home with a book where you don't have to talk to anybody for 12 hours. I love my introverts too. But,
I get that. Yeah.
Yeah.
But it's just so wonderful how, the music was such an inspirational and assuring gift for you. And because I feel exactly the same way. And so Cindy Cohn, thank you. Everybody buy Privacy's Defender. It is a fantastic read.
And by the way, all the proceeds for the book go to EFF. So if you think what we do is important, or if you don't and you just want to read the book, either way, EFF gets all the proceeds for the book.
Fantastic. Well, I really enjoyed that. So what do we take away from this conversation? First, I'll note that we recorded the podcast a couple of weeks ago, and I've personally spent a good deal of the past 2 weeks serving on a grand jury here in New York. And look, I'm probably being a bit naive here, as this should be obvious to many of us. But the thing that really struck me as I sat in the grand jury room over these past weeks is the pervasiveness of cameras all over New York City. On public transit, in retail establishments, bars and restaurants, outside on the street. I'm not sure there's anywhere one can go in this wonderful city where you are not on camera. And most of us go about our days in some combination of blissful ignorance and overt denial of that fact. And on some level, I think I need to admit a good deal of what we talk about in the ads regulatory space is somewhat besides the point. There's so much focus on companies guessing whether or not an unknown person on a computer might be interested in a new car or a vacation. And meanwhile, we've got what seems like a never-ending series of cameras literally watching our every move. Respectfully, I do not see those things being anywhere near equivalent. And I think there should be more discussion of the latter and perhaps a little less focus on the former. Okay, rant over. Back to my discussion with Cindy. I want to pull on 3 threads. First, the architecture point. I brought up Robert Moses, the urban planner who shaped New York by deciding where the roads went and how high the bridges were. Once the road is built, you've made a public policy choice that outlives every election. The internet works in the same way. The pipes we're laying today decide what's possible tomorrow. Cindy's answer was an air quotes here, an all of the above approach, and I think she's right. We didn't arrive here through architecture alone, or law alone, or business models alone. So no single tool gets us out. If you want a more decentralized internet, you can't just write a privacy rule. You have to fix the computer crime laws and the copyright laws and competition laws and maybe even the standards bodies. It's a lot of work. And one of the many reasons why I think we should all be grateful that people like Cindy Cohn exist. That's an uncomfortable truth for people who want one clean answer. There isn't one. But the flip side is one of hope. This concentration of power is recent. Many of us were alive before it existed. Or, in her words, Moses didn't come down from the mountain with a tablet saying that the only way to make money online is by spying on everyone. There are certainly other options, but equally, there are degrees of spying, and as I noted earlier, they are not the same thing and shouldn't necessarily be placed in the same bucket. Second, we certainly have points of disagreement. I come at these types of discussions from the perspective of the business community. My clients are smaller, VC-funded companies, and they're the ones who get crushed by a private right of action. They don't have the legal budget to survive an inquiry, even when they've done nothing wrong. Cindy leans more towards the consumer side, and she pushed back in a few places. We certainly had some disagreement on the efficacy of privacy-enhancing technologies, as I think there are a bunch of trade-offs in play when it comes to pets that don't get enough oxygen. And we also disagreed about the marginal benefit of behavioral advertising over contextual advertising. Cindy believes that it is not very big. I pointed to some of the recent privacy sandbox research conducted by Professor Garrett Johnson and his colleagues. I'll place a link to that research in the show notes. In my view, we need more of this type of research. It's worth noting where Cindy and I actually landed. We agreed that the current efforts to stop the race to the bottom keep missing big tech and keep landing on the small to mid-sized players. We agreed that the GDPR model and even some of the more recent state privacy models risk creating a world only the tech giants can afford to comply. And we agreed that the answer probably runs through competition and other avenues like copyright, not just privacy. And that's the part I want my listeners to understand. When Sam Altman goes to Congress and says, regulate us, and everyone swoons because finally a billionaire gets it, well, that's a sign that you need to look at what OpenAI actually proposed. If it's a framework where nobody but OpenAI is able to do what OpenAI does, everyone else is in big trouble. Cindy's warning is the whole thesis of this show. Regulation that feels protective can sometimes be the very moat that the incumbents want. Third, surveillance pricing. We talked about behavioral advertising and the Norway experiment to outlaw it. But the part that struck me was darker. Price discrimination. The idea that a company can read your desperation and charge you more or pay you less precisely because you can't walk away. Cindy was careful to say she hasn't confirmed the specific examples, and so was I. But neither of us doubts the capability is real or that AI makes it cheaper to do at scale. And here's the business reality. One airline gets caught, and suddenly 3 states have surveillance pricing laws on the books. The reaction to the surveillance pricing allegations has been nothing short of stunning, and the ad space needs to learn a lesson from this. A couple of additional points. I enjoyed Cindy's framing of surveillance through international human rights law, partly because I got into privacy by studying human rights, but also because human rights law just travels better across these new technologies than perhaps the Fourth Amendment's 18th century language. And Cindy's point that the telcos never went away as a vector for spying. We didn't trade one choke point for another. We just added a second and a third one. Let me close where she did. Cindy thinks that the next generation will pick up this fight, and the threat she worries about isn't the old nothing to hide line, it's nihilism. The idea that privacy is dead, so why bother? Her book, Privacy Defenders, is essentially a recruiting pitch designed to push back on that nihilism. It's a personal story as much as a legal one, and yes, there's a lot of music in it, which is another reason why she and I get along. The thing I would add, and while it certainly doesn't apply to Cindy, there is an endemic problem in privacy circles, where many privacy folks focus on purity tests. The idea being that anyone who doesn't embrace privacy to the degree that I embrace privacy is someone that should be ostracized from the community. I have a hard time with that mindset, and in any event, purity tests make it very difficult to build the kind of winning coalition that folks like Cory Doctorow talk about. I'll leave you with this. Buy Cindy's book. All proceeds go to the EFF. Buy it because the work matters, or buy it because it's a great read. But please, buy it. We've got a bunch of other fantastic guests coming up on the Monopoly Report podcast over the next few weeks. Please subscribe to the show at monopoly-report.com or on Spotify, Apple, YouTube, or wherever you listen to your podcasts. And thanks for listening.